Hey, thanks for tuning in to Between the Lines podcast. I'm Alex Woods, a former ICU nurse and founder of U.S. Legal Nurse Consultants. This show uses medical legal cases to explore judgment, strategy, and decision making. But what we're really talking about is how people think when there isn't a clear answer. The stories come from medicine and law right now, but the patterns, the missteps, and the strategy, it applies everywhere. This is about reading between the lines and knowing what to do with what you find. So let's get into it. Pat, let's get started. I want to know more about you. What first drew you into medical malpractice?
Well, I would say that medical malpractice for me started kind of early in the practice. I'm kind of an old timer, so back in the day, malpractice wasn't nearly as prevalent as it is now in terms of personal injury practices. In fact, a lot of the practitioners, especially outside the cities, used to be of the opinion that if you do malpractice, you're going to antagonize the medical profession. And those are the people that you need to testify in your personal injury cases. And they're very complex, they're very risky. And so there actually was an opportunity for me. I had to practice with my dad, who had a general practice for a couple of years. And it was interesting, it was fun, but I wanted to be in the courtroom. I didn't, as much as I admire a criminal lawyers, I thought it was a tough practice. You almost always lose, and your clients, by and large, not always, as we know, are guilty. And I really was attracted to the personal injury aspect of it, and so I started to solicit from personal injury lawyers in our community malpractice cases. And they were more than willing to refer them. And I just had to make up for lack of experience by just rolling up my sleeves and doing whatever's necessary to become acquainted with the medicine and the law and technique and how to work up a malpractice case and how to try a medical malpractice case. So, in the 80s, starting in the 80s, the malpractice area just boomed, certainly in the Chicagoland area and in the city of Chicago, in Cook County, which is our venue. And so, together with our getting better at it, the law firm growing from just me to where we have 22 lawyers based in Chicago and just representing plaintiffs in catastrophic injury and death cases, with about half of the practice being medical malpractice.
Hmm. Awesome. Was there a specific moment, Pat, or case that solidified your path?
Well, I would say, I have a couple of highlights that really I'm particularly proud of, kind of early on that involved trials. But I had a number of cases early on in my practice that, were particularly rewarding. One of my first, large verdicts was a brain damaged baby case in a very rural community. I had not tried a brain damaged baby case before then, so I put in that much more time and effort, blood, sweat, and tears. Our philosophy is, and mine has always been, it's very important to be the most prepared lawyer in the courtroom. It was a tough case. It worked out, record verdict. And I recall that after I gave closing argument in the case, the hospital lawyer stood up, and before he started, he said, I just want to say in my 35 years of practice, that is the best closing argument I've ever heard. And I turned to my associate trying the case with me, and I said, well, I hardly can object to that. So I knew that was a good sign, and, worked out. And that case actually went up on appeal and was affirmed one of the issues in the case was whether or not a doctor could give any testimony about the standard of care of a nurse for a nurse. And Illinois, like, most jurisdictions, kind of keeps the kind of, you got to be in the same sort of school of medicine, et cetera, be familiar with the standard of care and a different licensure, obviously, MD versus RN. But in that particular case, the doctor was, although he was criticizing the nurse, it had to do more with what a nurse would be expected to communicate to a doctor. And so the appellate court kind of carved out an exception saying a doctor can testify as to the standard of care of a nurse in the context of what would be reasonably expected to be communicated to him by a nurse. So, and that case is still, cited, some 40 years later or 35 years later, and we're proud of that one. And I've had the good fortune of many 7 and 8 figure and even 9-figure verdicts and with a lot of our great trial lawyers here at the firm. So it's kind of hard to pick out just, 1 or 2 cases, but that one way back in the day and in kind of a traditionally conservative community was particularly rewarding.
Yeah. No, I love that. I love hearing attorneys tell me about some of their first big wins or some of their first big cases. And you kind of
Yeah.
walked us through like what made it complex. And was it the jurisdiction? Was it the medicine? What was it that
Well,
challenged?
anybody that's done, say, for example, brain damaged baby cases, typically, whether or not there was mismanagement of the pregnancy, labor, and delivery, they know they are knockdown, drag out fights. So many areas of medicine that are covered both on the plaintiff side and the defense, and multiple experts, obstetrics, maternal fetal, OB nursing, placental pathology, pediatric neurology, neonatology, plaintiff and defense on damages, life expectancy, cost of care, all these things. And not only is liability a hard-fought battle, but also causation, because the cases kind of lend themselves to the defense, being able to point out certain things in terms of, did the injury truly take place during labor and delivery, or did it take place days or weeks, before mom even came in for delivery?
Mm.
And you've got to put together the case in a very persuasive fashion. Good experts, well credentialed. I like experts that are savvy with regards to, how you testify in a medical malpractice case persuasively. So those are all important. And it's changing. I think it's changing somewhat, say, in the last 10, 15 years. But rural jurisdictions are more difficult because, people still have a great respect for the medical profession, their doctor, or they believe that lawyers like us are responsible for their not having available obstetrical care or neurosurgical care, or, things of that nature. So, those are obstacles you have to deal with.
Have you found in some of these cases, like when speaking of liability, I wanted to ask you about this. We've worked on cases where the liability was maybe from a nurse or a provider, but do you find that juries are more empathetic to providers, but when the claim is a system-wide failure, do you think they are more empathetic towards the providers, physicians? And have you seen more of your cases won from the claim against a system-wide failure within the hospital?
Yeah, I think those are more winnable versus just whether or not a doctor or nurse at the time made a bad judgment call, kind of retrospectively you're beating them up, versus a clear failure. Usually we call it institutional or a system failure, where the hospital or the institution really should anticipate circumstances similar to your particular case, and they just didn't do it. Yes, I think those are more persuasive cases, versus the doctor or nurse that make a judgment call in a tough situation. And it turns out, even though it may have been reasonably based on what they knew at the time, turned out to be the wrong decision. Those are more difficult to win.
Yeah. Yeah. Thank you for that. Because I like to ask attorneys about that on juries and through your years and years of practice, have you found, I mean, probably in the beginning, did you discover that there was a lot more psychological than factual? Like did you have to change your strategy as you became more seasoned as a trial attorney in talking to the jury and in the language that you used?
Yeah, well, I think you become more savvy with regards to the cases you accept or reject, which is such an important component of malpractice. You have to be, in my judgment, very disciplined
Mm.
with regards to the cases that you accept, and never assume that, well, it's good enough, and yeah, there's all these weaknesses, but they'll probably settle. Those are recipes for disaster. There's nothing that hurts a firm more than, losing, multiple consecutive malpractice cases. It's terrible for the individual lawyer and the firm. It's disheartening. It's a blow to your confidence, and it's very expensive. We time and the expense of the cases. So I think it starts with that. You become much more savvy with regards to what cases to accept, and then who's going to be on your team in terms of expert witnesses and just how to present the cases. I think nowadays, even in rural communities, jurors are more skeptical of doctors and hospitals and nurses. They recognize that they make mistakes, some inexcusable mistakes. It's not the same in terms of, oh, I love my doctor and who am I to judge a doctor? That used to be more prevalent, earlier on in my career than it is now, even in what would be regarded as more conservative jurisdictions. That said, still, in order to win a malpractice case, in my opinion, I like to say you have to cream them, that preferably in order to win, because your defense lawyers in malpractice cases tend to be the better lawyers in defending personal injury cases. Not always, but they tend to be not only better lawyers, but they're very experienced, and the insurance companies have become much better in terms of helping the lawyer put together the defense, the expert witnesses, the whole strategy. They've become very sophisticated with regards to it. We have to deal with that.
Yeah, that's interesting. Do you encourage all your young attorneys that come through to get in the courtroom? Are you guys very trial focused with your attorneys?
Yeah, we are a trial firm, so we have 22 lawyers. So someone is pretty much on trial almost all the time in our office. Even though 9 out of 10 cases settle, 1 out of 10 in a fairly large personal injury firm is a lot. And in terms of malpractice, the learning curve is such that I think it is a skill that's kind of unique, and it takes time to learn how to do it in terms of selecting the cases, putting it together, selecting the experts, prosecuting it, taking great depositions, and then putting together, if necessary, a great trial presentation. It takes time. So someone will start out as third chair on some cases, second chair, then kind of 1A and 1B. It takes years.
Yeah.
And anybody that's tried cases knows that, and they see how things go when they didn't ask a certain question in a deposition or didn't nail down a certain thing in discovery, and sure enough, the defense kind of tries to wiggle through that opening. So the more cases you try, the better lawyer you become in terms of prosecuting the case. accepting or rejecting it, putting it together, and then particularly taking depositions.
Yeah, I had a call with an attorney yesterday and we were talking about that. We were talking about repetition, reps, get the reps in because improvement stacks on top of that and greatness will follow. And with trial
Yeah,
attorneys, I can only assume that it would take years because you have to build your storytelling too to be compelling.
yeah,
And what I've learned from talking to so many trial attorneys is keep it simple. And the more
yeah,
you over explain, the more you lose your jury. And
yeah,
so it's very interesting. The other thing that I have found interesting talking to you guys is I didn't realize that most cases settle just because, being on LinkedIn, you hear all these verdicts and you're like, man, it's just like left, right, left, right. You see all kinds of wins. And then talking to you and a bunch of other of you guys, you say that most of them do settle. Like most of them don't go to trial. Is that true?
yeah. I mean, the majority of cases settle. I think if you're doing your job right, that's generally how it should be. And in terms of accepting a good case, a very strong case, because what's going to happen if you know what you're doing and you're prosecuting the case appropriately, the other side is going to have their reviews and they're going to see the same things your people did when you first looked into the case. Now, they may be able to defend it, but they'll say to the lawyers or the insurance carrier, hey, I can defend it, but it's going to be a persuasive plaintiff's case. You may want to strongly consider trying to settle. Now, I think for real good plaintiffs firms, I think the obligation is that you provide extraordinary results. And in order to do that, you must have, in my judgment, a very strong trial record where you whack defendants consistently for amounts that are really kind of eye popping. And what happens is your reputation becomes such that if we don't pay top dollar to Salvi and his firm, his lawyers, they're going to take it to trial. They are not afraid to go to trial,
Yeah.
and they will be well prepared. They'll put on a great presentation. They're going to ask for a tremendous amount from the jury, and more often than not, they get it or close to it. So let's cut our losses, and
Mm.
even though we're paying a lot more than we would like, I think that's the obligation of truly great firms is not just giving the client a pretty good result or that's pretty fair settlement, but really an extraordinary result. I think that's the obligation of firms like ours where we accept cases based on reputation or from other lawyers. I think that's really our obligation, and that's the culture we try to pound into the lawyers in handling the cases every day here.
Thank you for that. I often hear that failures are our biggest teacher. Thinking of a case, one that you lost or you didn't get the amount that you really thought that the client deserved. What was one of your greatest teachers case wise, and what did it teach you?
Well, knock on wood, I haven't had too many humbling experiences, and not that I'm not anybody that's been in the malpractice field says they never lost is probably not gone to trial very often. I would say kind of early on in my career, and we were talking about it before we started the program, and in terms of septic shock cases. And I had early on in my career, I had a case where a person died of, we said septic shock. They disputed whether there was septic shock. And I'll never forget the defense lawyers, or defense experts said, just sort of concluded, hey, you can't have septic shock without shock. And, sort of arguing that there, really the criteria for shock was not met. And I was too focused on very minutia detail of medicine and did not simplify it. I was too worried about getting into the weeds with the experts or even the jury and opening statement and closing argument on the medicine, and it didn't simplify it. And, I still think put on a great case, but the jury got the case on Friday morning, deliberated. And I know I had some jurors on my side, wasn't sure how many. And they deliberated all day Friday and then just couldn't reach a verdict, wanted to come back on Monday. And I just knew that was a bad sign. And eventually the jurors that were skeptical and just kind of wore down the plaintiff's jurors, and it was a not guilty. And another thing that impressed me, and it was the fact that my defendant doctor, although I believe in my heart of hearts was negligent, not a bad doctor, but in this instance, negligent, was just a great guy. Likable, persuasive, thoughtful, and that makes a huge difference. There's nothing more distressing than sitting in the courtroom and watching the defendant save his case or her case. And you can just see it slip away, especially with a good defense lawyer and a well-prepared, likable doctor who step by step, explains why everything the plaintiff's lawyer has been saying for the last 2 weeks, is not really fair or taken out of context or not really the whole story. So that was a humbling. Those are humbling experiences.
One of the attorneys I talked to, Scott Weidenfeller out in Michigan, he said the same thing. He said sometimes you just never know sometimes when a case is going to go to trial. You think you have it, like all the facts lined up. You're like, there's no way that this is going to go to trial, and it goes to trial, and then you really, the goal is to connect with the jury and tell them a story of what happened instead of beat down with like the nuances and all the discrepancies. And experts matter. One of my attorney clients, we locate experts, and he always asks me, because we vet them. He said, how'd they sound on the phone? So Pat, what's something you and your firm have done that's elevated your practice today, whether that's strategy, process, AI integration, because I know that's a big thing right now with AI that's helping the practice more effectively, connect with juries, or serve your clients more powerfully, whether that's focus groups or whatnot.
Yeah, we're a big believer in focus groups. That's one area we utilize quite a bit. We have, our philosophy is we're pretty selective with regards to the damage criteria that we insist upon with regards to each case. So some people accuse us a little bit of overkill, but we'll have almost always not less than three, usually four lawyers to a team. We, depending on the case, we may not have all four sit at counsel table during a trial. I think one area that we utilize a lot more, and we'll do like multiple focus groups, because during the course of discovery, you things change, you learn additional information, you know more what the defense is, and so you can test those things out, and so we utilize that quite a bit, and just kind of internally, we're very much interactive with regards to multiple kind of sessions with the lawyers who are not on the case, being presented the case by the trial team, and kind of picking it apart and pointing out strengths and weaknesses. So that's a big aspect of our practice currently.
Are you guys using AI in your firm yet as far as record review?
Yeah, I think, we do, especially with regards to, kind of like summaries and literature. And, it's a good source right away for medical information. What's this disease? What are the signs, symptoms, or complaints? What are the treatments? What are differential diagnoses? Those are very handy with regards to quick information. We're big utilizers now of jury questionnaires. We've incorporated those more with regards to voir dire, jury selection, and just some of those things that, a lot of the real good firms are familiar with.
Yeah, with AI, I mean, there's always the debate of accuracy, but I know there are some phenomenal AI companies out there. I've been in talks with quite a few of them to integrate even in our practice. I know some attorneys are like, "Do you use AI to review your records?" And no, we put eyes on everyone. However, to make our practice more efficient, less time, less money for you guys as well. If you're not using AI, you're gonna get left behind. We use Grok, GROK.
Yes.
That's phenomenal for
Yeah.
literature. I mean,
Oh
one of
no, you've got to use it. At the end of the day, though, there's no substitute for, the blood, sweat, and tears you need to put into.
yeah.
You can't abbreviate too much your preparation.
Mhm.
You can use AI, to be more efficient. I'm still a little bit old school, and I cringe when in our jurisdiction someone gets scolded or even sanctioned for, citing cases that don't exist. That's kind of a scary
I've heard
that's
of
kind of a
that.
scary thing. Yeah, knock on wood,
Crazy.
we haven't had that happen, but you got to be careful of that.
Yeah, I've heard of that over the last couple of years. That's insane. In your experience, what is an overlooked factor that can completely change the trajectory of a medical malpractice case?
Yeah, I would say even with regards to experienced practitioners, they're still, and I notice with kind of some of our younger lawyers, is there isn't enough thought given to a very clear step by step connection between the deviation from the standard of care and the ultimate outcome. And a very clear, simple, easy to understand, yet persuasive and supported by medicine, step by step. So the patient came in with these signs, symptoms, or complaints. The doctor deviated from the standard of care in failing to do a CAT scan of the abdomen. What would the CAT scan more likely than not have shown? It would have shown this disease process. Okay, this tumor, whatever. Okay, what in your opinion would have been the result of that finding? It would have resulted in this treatment, biopsy, and what would that have likely, and then it likely resulted in this diagnosis. And then what would the treatment have been? The treatment would have been this. Well, how do we know this would have been effective? Well, we know if this medication is given or this surgery is performed and this number of circumstances, 90% it's cured. Okay, and so I believe it or not, I think that there's still not early on from the very get-go the necessity of putting together as important as the deviation is, the step-by-step causation that clearly makes the jury understand the causal connection between what the doctor did or failed to do and the death or the ultimate outcome. And, because the defense lawyer obviously can say, they have the obligation to meet every element of malpractice. They must prove every element, every issue. You must believe more likely than not, they've proven it. If they don't prove one of them, we win. NG. And so oftentimes we got to put this together last minute, or got to explain the whole thing, or it's kind of assumed, well, since they screwed up, it must have caused or contributed what caused the death. But it takes more than that. Most persuasive is just not the expert saying that, yeah, the failure to do the CAT scan caused or contributed what caused the death. Yes, it should be very clear, step by step, what would have happened, reasonable, persuasive, easy to understand. I get that. That's why the plaintiff should win.
That is so good, Pat. That is going to help me just reviewing cases. Man, you
Yeah.
spot on. Just help me and my team just go just even a step further. Oh, that's really
Very important when you review them, think of that and then walk the lawyer through it and have supporting data, literature, whatever makes your case, they should have done a spinal tap. Why? Because this age of child, these findings, these complaints, these labs, okay. And then what would have happened if it was done? Would have been positive. Would have we know what the bacteria was that ultimately? So that's what it would have been. We know that this would have been the treatment, this broad spectrum antibiotics, and we know, and here's the proof that how effective it is. Baby's cured instead of baby's brain damaged. So I think, in terms of both the lawyer and someone in your profession, you're doing a great service to your client by, walking them through, not just saying, oh yeah, they screwed up here and there, but let me tell you, how you present your case step by step in terms of how it ended up killing the patient or seriously injuring the patient.
I mean, the way that you articulated that, just step by step, clear, and ask the why questions more likely than not. I'm reading some of my notes that I had written down, but that's really good, Pat. Thank you. When a client comes to you and says that they have multiple attorneys or, they saw you guys online, why should they choose you? Even from me, like an ICU nurse, or if I have
Yeah.
a friend, why should they come to your guys' firm?
Yeah, that's a great question. And we are frequently competing for cases, especially, particularly serious ones that on the face of it appear to be, meritorious or something probably
Mhm.
went wrong. And so, I mean, no matter how much glitz and glamour and how slick a talker you are, you have to have a track record of success because, at the end of the day, you can be, a very persuasive salesman. But if you don't have the track record of success, almost all clients of various levels of sophistication are going to go with the firm that, can really say, hey, we have done it in the past over and over. We have a great track record. And so, I think that's number one. You have to be able to show that, no getting around that. You have to use your lawyering skills, not in a bad way, not in a not in a fashion that's not genuine. But I try to honestly persuade the client in a very sincere fashion that they've come to the right place. They've done their diligence, and that's one reason that they're in my office talking to me. We're going to meet their expectations. We're going to be communicative with them. They could not have a better lawyer. They must believe that. They are in the right place, and we're ready to work on the case right now. Um, it's not that you discourage people from getting a third or fourth opinion. I want my client to believe. I'm not gonna say, hey, cancel your other appointments with other lawyers, but I'm not going to badmouth any other law firm and unless they're seeing somebody that, in my judgment, is simply not competent. Usually we're competing against the same 3 to 5 firms that we always are, and they're great firms. I mean, it's a very rewarding practice, professionally, financially, and so as a result, and in our jurisdiction, our venue is very good. Illinois is a great state for personal injury and medical malpractice. Cook County is a great venue, but the state is I tell the lawyers, you're fortunate that you're in a state, no caps, not only the laws, the substantive laws, but the rules too, the rules of the game in terms of of a malpractice case. No, they're not skewed so that we win all the time and the defense loses. No, but they're not like some of these bad states with tort reform, that make it close to impossible to win a malpractice case. And even if you do, there's a cap on non-economic damages or worse. Now, as a result of our being friendly to plaintiffs, there's a lot of competition. But not to be long-winded, I like the clients to feel as if they've come to the right place. We will provide an extraordinary result. We are very empathetic and communicative, and they've landed in the right place. Now, we probably have 10 of our lawyers are very accomplished, and probably a half a dozen in the area of malpractice with great track records of 7 and 8 and 9-figure verdicts. And so I don't, unless I mean it, a client may say, well, are you going to try my case? And if I'm not, I'm honest with them, but I have, I have with me, or that person may be taking the lead in terms of, interviewing the client, being the lead counsel on the case, and they have a track record enviable as anyone they're competing with. You make the client feel as if they're in the right place. They selected the right lawyer, and he or she's ready to go.
I can hear it in your voice too, just how passionate you are about what you do. And I'm sure you've instilled that with your two sons and your daughter-in-law. And when you built your firm, what are some of the values that you put on your forefront, like mission, business owner to business owner? I love talking about this. What are some of the values and culture that you wanted to put in place in the firm? And then on hiring people, that you wanted people to emulate those kind of characteristics?
Yeah. Well, number one thing you learn as you build a firm, trial and error, is you really need to take the time and the effort and do the diligence to select the right people, lawyers and non-lawyers. The lawyers, not to diminish, our paralegals, our assistants, our tech people, our marketing, they're all, I'm biased, but they're all outstanding. And what you want to do is build the culture that you are, you're the best firm in the city and the state.
Mm-hmm.
And that someone should feel proud to be a part of our team. Now, in order to do that, and I've made mistakes, hired people for the wrong reasons, and you learn from those mistakes, and you have to make sure that you have people that share your same work ethic, passion for plaintiff's work. I like people that are very competitive, because people that are very competitive, what do? They know they work as hard. They do what's necessary ethically to do what you need to do to win.
Mm-hmm.
They will spend whatever time, whatever effort, blood, sweat, and tears to win. They hate to lose. Not afraid to lose. You can't be afraid to lose. There's a lot of really talented, smart lawyers that know how to work up a case, but they can't bring it home. They just don't have I would say, the ability to look past the fact that, everything's not going to be perfect in a trial. When you're dealing with human beings, you can't script everything out, but you must trust your talents to be able to deal with some of the things that you didn't anticipate. And, you have to be really fearless, not reckless, but fearless. And it's hard to find lawyers that have all of those attributes. If they don't have a long track record of experience, you have to sort of see if you can sense that, when you're deciding whether or not to hire somebody. And sometimes you make mistakes. And if you do, I think you need to move on. Now, we've had the good fortune of the lawyers that we have here, have been here 5, 10, 15, 20 plus years. And so, I think that speaks well. As you mentioned, it helps me to have my son and my two sons and my daughter-in-law. I have to be careful not to, show favoritism. I love all my lawyers, and but they have various levels of experience. We have new associates, and we have, I think some of the best trial lawyers in the city and the state, have worked for us for years. So, it's very heartwarming. But I think that's the key. Have them share that same culture of excellence.
Mm-hmm. Yep. I love when I'm talking to nurses and legal nurses and hiring more subcontractors. I like talking about sports too. I played three sports in high school, and like that competitiveness and that work ethic. My dad was in the military. He never complained about anything. You can kind of tell when you're
Yeah,
talking to people if they have that grit. And in this field, in your field, in any field where we want to be the best and we want to grow big, and you have to sell them almost on the vision and the mission. And if you want to get better and be better, to do better, to give better, all the things, these are the values that we have here at our company, and this is the people that we look for.
I agree with that. Reminds me of that. I forgot the name of the movie. It was Owen Wilson he was interviewing, and he was asked, do you have any questions? He said, "Yeah, what's your policy on Columbus Day? Are you off that day?" So that would be a red flag. And the guy said, I think the guy said, "We worked that day." He goes, "Oh, really? The guy that discovered America?" And so, if you pick that up, somebody that is sort of risk adverse, they're more worried about, paid vacation than, what kind of cases am I going to get to try? Those are things you kind of look for.
Yeah, yeah, for sure, for sure. Well, Pat, seriously, thank you so much for getting on. I had such
My
a good
pleasure,
time. I
Alex.
learned so much. Where can people go to learn more about you? I know you're on LinkedIn, email, website, other social media platforms that you guys are on.
Yeah, I think the easiest our website is www.salvilaw.com. So salvilaw.com.
Okay.
That has I think we have a really good site.
You have a really good
Uh,
site.
yeah, really good site, and all the bios and all our track record, which we're very proud of, and
Yeah.
I'd put up with anyone. So that's a good source.
Hey, if this episode changed the way you think or gave words to something that you already practice, subscribe so you don't miss what's next. And if you know someone who makes high stake decisions, maybe solves complex problems and works in gray areas, send this episode their way. Between the Lines is for people who care about how judgment actually works. We'll see you on the next one.